The following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as the public records and freedom of information laws. The content may include adult themes, concepts, or language not suitable for all audiences. Viewer discretion is advised. Welcome everyone back to your favorite cubbyhole on the internet, and we are here with a special weekend edition ahead of the DVRO trial. That's the long-form trial taking place on Tuesday and Wednesday this coming week in San Francisco. Those of you following this know that the amazing Megan Fox and a few others are going to attend the trial. We do not get a look into that window, so we will all have to pay attention to the tweets and the reports that come out of that trial each day from all of those people. We will be watching, as I'm sure the rest of you will be as well. But today we have a treat especial on this weekend edition. We are going to cover the filings, the witnesses, and the exhibits for Mike Marraccini, and most especially, where all the entertainment is, Laura Owens. So we will begin with the more reasonable and staid filings by Mike Marraccini, written by Omar Serrato, counsel for Respondent, and Rachel Juarez, co-counsel. Let's zip through this fast because the good stuff is what Laura's trying to put in, and it's very entertaining. It's a shit show, or as some would say, it's a clown show. It's entertaining. It's just good stuff because it's insane, and most of it's not relevant, as my other colleagues covering this have very well pointed out by now. So here we have Mike Marraccini's Respondent's exhibit list, and we'll just kind of read through some things. Respondent, Michael Marraccini, by and through counsel, herein submits her, actually I think that should be his, list of exhibits to anticipate to be used during the procedure. Respondent Mike Marraccini reserves the right to amend the list. And we have very concise lists of various things. I won't list them all specifically, but we have the ruling from Judge Mata. We have the criminal indictment from Superior Court of Arizona. We have correspondence from Dr. John C.K. Chan. We have correspondence from Dr. Yee, the San Francisco police report and picture of investigating officers, images of Laura with redness around the eye, digital forensics report from John Berryhill. We know that John Berryhill has been called as a witness, so that will be very interesting. The chicken soup for the soul flight story. I wonder if that includes both printed and digital media forms. The petition for the order of protection against Clayton Eckert. The subpoena issued by Superior Court of Arizona to Mike Marraccini. Civil complaint against Greg Gillespie filed by Laura Owens. Petitions of order of protection against Gillespie by Laura Owens. A positive pregnancy test by Laura Owens. Text message from Laura Owens concerning miscarriage. Text message from Laura Owens concerning miscarriage again. Facebook post from Laura Owens at KGO celebration. This was the infamous picture where Laura claims she was going to the hospital because she's pregnant. And then there are other postings of her on Facebook, as a matter of fact, drinking champagne, ostensibly, at a KGO celebration for Ron. We've seen that image. I think I've brought that image up in a previous video. We have text messages by Laura Owens claiming her twin pregnancy was no longer viable and that she would be taking abortion pills. If it's not viable, why would you take abortion pills? Someone explain this to me. It doesn't make sense. We have Laura's deposition with the Eckert case and the oophorectomy thing. We have equestrian rider reports. We have the petition on the order of protection by Greg Gillespie against Laura Owens. We have a text message from Laura Owens to Mike Marraccini. That's the I love and trust you thing. We have another text message from Laura Owens, and that I'm horny, baby. I wish we could get dinner. Then we have an email from David Gingras. We have Laura's email inbox sending that she is the anonymous woman so she could get credit for it and make certain she could use that to her advantage. We remember seeing that inbox. I think we've looked at those images as well. We have the state's notice of disclosure and request for disclosure filed by the state of Arizona. Text messages from Laura regarding inpatient psychiatric therapy. Declaration of Laura Owens from March 29, 2018. Post-trial findings by Judge Mata. And a petition to the court order paternity filed by Laura Owens on August 1st. And that's submitted by Omar Serrato. It's not very interesting, is it? Very concise, very to the point. Let's get to the other stuff, shall we? Hold, please. Hopefully everyone used the hold music to go grab their beverage and their popcorn and whatever else, because this is where it gets exciting, or at least interesting, or perhaps entertaining. And here we have witness number 1, David S. Gingras, Esquire, former counsel for Laura Owens and Owens v. Eckerd. And he's called as a fact witness, and I'm interested, if not intrigued, that we have little times next to it. We're going to spend 60 minutes with David? Oh my God. Can he even last that long? That's my question. I'll be here all weekend. And against good practice, we have long-form narratives over each witness, and we're going to read it all. So here we go. Attorney licensed in Arizona and California who represented petitioner in her 23-24 paternity case against Clayton Eckerd. Mr. Gingras is expected to testify as a percipient witness regarding respondents' continuing violations of the San Francisco Superior Court DVRO. He showed up to a subpoena at Clayton's thing. Oh dear. Oh no. Oh no. He showed up to a subpoena in Arizona. Oh no. Isn't it interesting that we don't say that we lost that case? Oh dear. Continuing on. Mr. Gingras will testify that on April 19, 2024, respondent's attorney Randy Sue Pollock confirmed in writing that my client will not be testifying in the Arizona paternity case. Despite this assurance, because I, Laura Owens, have been wronged so deeply by not being allowed my way, that respondent traveled from California to Phoenix and appeared in person at the Maricopa County Superior Court on June 10, 2024, where he sat approximately 20 to 25 feet from me over 2 hours while I testified without permission, without my permission as Laura Owens. Damn it. You have to have permission from me, Laura Owens. I'm the queen of the universe. Okay, it doesn't say all that, but this is value added. And it's in direct violation of the San Francisco Protective Order, prohibiting any contact. Bullshit. Tough tits, Laura. He was legally called as a witness, even though he didn't get to testify at the paternity case. Too bad. Mr. Gingras immediately contacted court security and several local law enforcement jurisdictions. I think it was 3 officially. After petitioner became visibly distressed on the stand, providing documentation of the active order and requesting enforcement. That's not quite the sequence in which it happened. Not remotely. Mr. Gingras, before court even began, made an issue. Court security was involved. The court decided that there was nothing that prevented him from honoring the subpoena they had issued for his apparent testimony appearance, even though he, again, did not get to testify. David Gingras, probably dealing with a hysterical Laura Owens, as we have seen in videos recently. Go back to my videos of the raid on the casita for exact evidence of how this crazy bitch behaves. No, Mike showed up. He was nowhere near Laura. They went through security. There was not an issue. Court security was aware. They were prepared. But that wasn't good enough for Laura Owens, nor David Gingras being the puppet. They kept calling around various police departments, ostensibly, allegedly, that include, who else? How could there be 3? Let's see, the sheriff, the local PD, which I think would have been Phoenix. And then what else would there be? The highway patrol? I'm not sure. But supposedly there were 3 different law enforcement agencies called, and 0, absolutely none of them, got involved to haul Mike away. That demonstrates, since he had a valid subpoena to appear at the Owens v. Eckerd case, he was very much required to be there. So this is all blustery bullshit. And our next person. Oh, there's more. Oh, we're not done yet. Following this incident, I got ahead of myself. I should have turned the page. Following this incident, respondent publicly admitted in a recorded interview with media figure Megan Fox that he attended the hearing knowing he was not going to testify. That's just a foregone conclusion. That doesn't make it a crime. When you know each side only gets about 50 minutes and you've got so much to cover, odds of being an extra witness are pretty slim in such a short trial. But he was there legally, lawfully, and requiredly. Had he not shown up, that could have been a problem. Mr. Gingras also possesses knowledge of Respondent's involvement in providing a laptop to a forensic examiner that resulted in a 2,489-page extraction of petitioner's private text messages, which were leaked online to the group Justice for Clayton, which is dedicated to harassing petitioner. Oh no. Whatever are we going to do? I still haven't seen all 2,489 pages, or as Dingus the douche canoe,
The fucking douche canoe.
usually referred to it, the 2,500 page leaked stuff onto the blah blah internet. I haven't seen it. Supposedly there's a couple of things on the victim of Laura Owens. Volo, shout out. I haven't seen it. I haven't gone looking for it because, quite frankly, that's a lot of pages, and who wants to see all of the back and forth between Laura and Mike? Most of it's not interesting, I'm sure. But there we go. And our second contestant is Mike Marraccini himself, respondent in underlying case. He is expected to be cross-examined regarding his continuing violations of the San Francisco Protective Order, his repeated public misrepresentations about petitioner. Oh dear, he's not allowed to have an opinion, and his ongoing use of coercive control and reputational abuse. What is reputational abuse? Let's see, where's Google Girl? Is there any Google Girl for reputational abuse? Is that even, we're making up words. I see nothing for Google. If such a thing existed, I would like to sue people for reputational abuse myself. My detractors, that is. It's too bad it doesn't really exist. That's called defamation. See, what this is going to be, folks, in case you haven't already figured out, have you not seen any of this documentation before on the other channels? This is going to be Laura Owens trying to turn a DVRO into a defamation hearing. It's not going to be that. And most of this is going to be irrelevant. Continuing on, Respondent has engaged in a sustained campaign of post-separation harassment, including a 2.5-hour interview with media figure Megan Fox, during which he discussed the protected case. What's a protected case? Oh God, this is just tantruming in print. I'm surprised it doesn't have a few more dramatic descriptors just to make up for the lack of being able to write Medium blogs. Oh dear, disclosed private details about petitioner's mental health and made false, humiliating statements designed to damage your reputation. Sure, whatever, I don't believe it. In that same interview, see, it keeps going. Each one of these is going to go on for paragraphs. Medium blog, trial edition, I guess. In that same interview, Respondent admitted that he traveled to Arizona for the June 10, 24 Owens v. Eckert hearing, despite knowing that he wasn't supposed to testify. I mean, he wasn't going to be testifying. He neither sought nor obtained authorization from the court in San Francisco in violation of the above restraining order prohibiting contact and proximity, and he can't say anything about me unless I, Laura Michelle Owens, give him permission. I am such a controlling bitch. I have to control every second of his life. He has to ask me for everything, including using the damn toilet. Am I getting too dramatic? I might be getting a little bit excited. Okay, let's turn that down a little bit. There's no caffeine. This is all natural, folks. There's no caffeine here. There's no other substances either, for that matter. His deliberate disregard for the order and the court jurisdiction constitutes a willful violation of 18 U.S.C. and Family Code 6320, which none of it does, because MG Law talked about it for a number of hours, how all of this is bullshit. Reflecting ongoing coercive control and intimidation. She's such a freak. Respondent also leaked or authorized the publication of private text messages between himself and petitioner. Communications covered by the DVRO, no they're not, to the third-party online accounts associated with Justice for Clayton Network. Ooh, Justice for Clayton Network. Let's write a jingle. Brought to you by the Justice for Clayton Network. I like that. It could be useful for trolling, I think. Let me just make a note to myself. Hold, please. We've got that written down. Notes for my production staff, meaning me, myself, and I. These acts were intended to retaliate, harass, and humiliate petitioner in direct violation of the spirit and purpose of the protective order. She needs no help humiliating herself. She really doesn't. If it's not enough falling off horses, the outlandish, outrageous behavior of her having absolute shit fits on the body cam footage are certainly enough. Oh, yeah. Okay, I might have something to say after each paragraph. This is so much bullshit. In pleadings filed through counsel, respondent further alleged that petitioner traveled to New York to confront his employer's HR department and asserted that she has pursued communication, harassed, and publicly confronted him, claims that are entirely false. Petitioner has had no contact of any kind with petitioner since 2018, has never known his employer's name or address, and has not initiated or encouraged any communication or confrontation. These knowingly false statements to the court illustrate respondent's ongoing fixation and continued efforts to weaponize litigation and public narrative to punish and defame petitioner. There's no defamation in the truth. This is why Laura Owens and David Gingras hate every single one of us so much. They don't like the truth. They don't want to live in the truth. And they certainly don't want people exposing the truth. And we might talk more about financial fraud and how someone's getting a financial colonoscopy ahead of their criminal trial in the state of Arizona. That may be next, folks. We'll see. I've got a few more things of paperwork to collect for that one. Respondent's conduct, including the willful violation of a standing protective order, public exploitation of confidential material, and dissemination of defamatory narratives. Laura Owens would probably try and sue me for defamation for telling the truth because the Laura Owens truth is defamatory against her. It's an unbroken pattern of coercive control and more reputational abuse. Isn't that amazing? Where is that listed in any statute? Warranting renewal and extension of the protective order under family code. Blah, blah, blah. Bullshit. Witness number 3. Peggy Marraccini and Stephanie Ash. Actually, that would be 3 and 4, not just 3. Someone can't count. Also, only 45 minutes total. Right. I wonder how we concluded how much time we would need. We've never held a trial before, have we? We've never certainly run one as our own representation. So I think, could there be more dingus DNA dribbling all over this? I wonder. I would suspect yes, but that's just my suspicion. That's my opinion. They are expected to testify regarding their close and frequent relationship with petitioner during her relationship with respondent, including multiple family gatherings, dinners, and shared events between Marraccini and Owens families. Both women personally witnessed petitioner experience a grand mal seizure in Petaluma, California on May 13, 2017, shortly after an incident of physical abuse. No, I don't think so. Could that seizure be related to falling off a horse, I wonder? Yeah, because people are standing around watching abuse and there's a seizure. Come on. Save your bullshit for somebody else. Save your bullshit for the horse barn. Go get your shovel, Laura. Peggy Marraccini sent her son a text message the following day stating, "I don't want you to be my son because of how you treated her." Prove it. There's no citation of this being an exhibit, is there? Isn't that convenient? Which even respondents on witness John Berryhill acknowledged as authentic. Yeah, sure. Where is that? I don't see it. Her contemporaneous messages to petitioner describe her as so loving and caring and so blessed you are home with your sister and daddy. God, cherry-picking texts confirming the seriousness of the relationship and undermining respondent's current claim that it was a casual or delusional what? Relationship, perhaps? Petitioner also retains multiple voice emails from Mrs. Marraccini, many recorded after she had distanced herself from respondent, in which Mrs. Marraccini, would it be Mrs. Marraccini? Pleaded for renewed contact, reflecting both emotional distress and implicit recognition of her son's culpability. Something tells me this is not how it would go on the witness stand. I don't think it would go this way at all on the witness stand. Oh, if only I could be there. I'm so sorry I can't be there, folks. I can't get the time off. Oh, that's the way it goes. I'm saving all of my get out of jail points for time off for the criminal trial, because really, in the end, until, if and or when, this gets turned into a criminal referral, I want to keep my eggs for public attendance in the criminal basket for Laura Owens. I think that's just good balance. All the other things, I mean, they're exciting, they're interesting, they're entertaining. But what we want to see is actual justice, not just, the little slap fights of Laura getting off in court and trying to punish and abuse men via the court system, as she's been doing for the last decade plus. That's not something I necessarily need to see, although I'm sure since she's representing herself pro se in San Francisco, there could be some meltdowns, which could be entertaining on their own. But again, we'll have to wait for our on-the-ground reporters, Megan Fox and others, to give us all of the news as it unfolds in that trial on next Tuesday and Wednesday. So that'll be fun. I'm going to have all my notifications turned on because I'm sure there will be lots of people talking about it who attend and either hopping on their lives afterwards or posting lots of stuff. That'll be great. Oh, let's see. Stephanie Marraccini, blah, 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 socialized with petitioner. Oh, we're accusing Sister Stephanie Marraccini, now Scanlon, being online and being part of Justice for Clayton, allegedly posting under the handle Justice for MM. Where's the proof? I don't see any proof of that here. She's publicly identified herself as Respondent's sister and leaked previously unseen photographs she personally took of petitioner to Justice for Clayton Official, the Instagram account. Oh dear. Oh no. These images include a horse show and private dinner, and confirming her as the original source because only she had that, by Laura's supposition. Taken together, Peggy and Stephanie Marraccini's prior statements, actions, and communications provide direct, independent corroboration of Respondent's abusive behavior and evidence of coordinated ongoing efforts by his family to intimidate petitioner and undermine the protective intent of the prior court orders. Blah, blah, blah. Bullshit, 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 bullshit. No, it doesn't. No, it doesn't. Doesn't work for Family Code 6345 either. Okay, moving right along. Callie Subsinskis. This is the one that Laura made up the story, where Mike was talking about someone tall and blonde and not like Laura, blah, blah, blah. This is that person, according to Laura. A former intimate partner. See, why does that matter? And of course, this is going to be relevant too. Of Respondent, who independently contacted petitioner to confirm that petitioner's prior warnings about Respondent's behavior were accurate. In her messages, Ms. McLean, some things happened and I would prefer to stay far removed from him. And I just wanted to say thank you for giving me the heads up on Mike, and I apologize for not believing you at the time. Woman to woman, I just want you to know that I appreciate what you did. She also wrote that she blocked him on every platform to avoid further contact. Although communication occurred in 2018, Ms. McLean's account remains highly relevant under that family code, even though the judge said we couldn't have it in. But I'm going to try and use it for a smear campaign in the courts. That's what that says. I'm paraphrasing. Moving along. Julia Brozek, the competition safety coordinator for the USEF, is expected to testify as a neutral records custodian and expert witness regarding petitioner's official USEF competition history, safety logs, and incident reports. How many horse falls and smacks on the head will be listed, I wonder. In Respondent's motion to dismiss, pursuant to that, his counsel alleged that petitioner rebranded horsefall injuries as domestic violence bruises. Citing competitions in February 2017, Ms. Brozek will testify that USEF's official safety records reflect no reported falls, injuries, or on-site medical incidents, blah, blah, blah. This can't be admissible because it happened before 2018, so it's going to be absolutely irrelevant, but we're going to blabber on about it. We're going to say we didn't have any falls or incidents, even though Stephanie and Peggy Marraccini, both independent observers, confirmed that they were present on the day that someone had a seizure while mounting a horse, that they were observers and were present and followed petitioner by car to the hospital. Oh dear. USEF's mandatory reporting protocols require documentation of any ride or fall or medical transport. No such records exist for petitioner at any time of her competitive system, even though there's lots of video footage of her falling off horses. We're going to claim that there's no... Do we have a special friend at USEF who's going to lie for Laura on the stand? Is that what we're getting to here? The overstatement of them being a neutral records keeper makes me more suspicious that they're not neutral, nor are they a good records keeper, especially when there's so much video footage of Laura falling off of horses. Our next person is Karen Ambro Bernatus, formerly Illenberger. That's Napkin Lady to everybody. Evidently, she exists as a real person. I wonder, I would love to hear her testimony, although it will not be admissible because the situation dates from 2016. But let's read the narrative write-up, even though it's irrelevant. Neutral third-party eyewitness who personally observed respondent verbally and emotionally abused petitioner on a flight in 2016. Ms. Bernatus wrote contemporaneously that respondent was so menacing that I felt her life was at stake were she to stay with him, and slipped petitioner a note urging her to seek help. It was a note for Laura to seek help, but it wasn't a note for Laura to seek law enforcement. Isn't that funny? Okay, we know what Napkin Lady said. I'm waxing poetic. I don't know why. It's Saturday. It's Saturday, and I'm spending it with you all reading this bullshit. This is just so crappy, it's not even funny. Well, maybe it is funny. Maybe you're finding this entertaining just because it's so outlandish. The next paragraph, in 2023, Miss Bernatus publicly recounted the same event in Chicken Soup for the Soul. Chicken Soup for the Soul. Why did I read that again? In 2023, Miss Bernatus publicly recounted the same event in Chicken Soup for the Soul. Get out of your comfort zone, Simon & Schuster, writing that the situation was so dangerous that I couldn't even risk sharing my phone number. Her recent publication provides contemporary corroboration that an uninvolved stranger perceived respondent's conduct as life-threatening, supporting the continuing reasonableness of petitioner's fear and the need for renewal of protection. It's still an event that happened before 2020, which was the judge's ruling. It doesn't matter if it was rewritten years later. Probably at Laura's insistence, I would bet. I would be interested in her testimony nonetheless. I think she would be very fascinating lady to cross-examine. Very fascinating. Records custodians, Child Protective Services and HR Department, Respondent's employer in New York. I thought we didn't know who Respondent's employer in New York was. I think we've just been caught in another Laura Owens lie. What a shocker. Oh, should we cash in on that one? I could have cashed in on several more lies, but I don't want to overuse that button and wear it out. Those people are expected to testify or provide certified documentation regarding two discrete factual issues raised by respondent in this proceeding. First, the CPS records custodian or assigned investigator is expected to confirm that a CPS report concerning respondent was received and investigated in 2024. About what? What children are we talking about? This doesn't make sense. Petitioner was not the reporting party, and CPS records confirm that neither petitioner nor any member of her family was identified as such. The report's existence became public only after respondent and his online affiliates discussed it on Reddit. Oh, I must have missed something on Reddit. I'll have to go back and look. Falsely accusing petitioner and her family of making the report. In reality, the report originated from an independent third party. Who could that third party be? Could that be Laura Owens under a pseudonym, maybe? Under some name, just like a Planned Parenthood Admission Viejo? Oh, let's see. Who found respondent's conduct sufficiently concerning to alert authorities? Yeah, I don't believe that either. The fact that a neutral observer is viewed... How would you know this? How would we know this at all if you're not even the reporting party? This is suspicious. Obviously, Laura Owens is stalking every bit of social media she can. Laura Owens is not only an abusive, conniving bitch, she is an online stalker and harasser. That's my opinion, but I think it's factual. The fact that a neutral observer reviewed... Let's just skip all this. Let's move along, shall we? To continue to perceive him as threatening. We'll just keep using buzzwords like threatening and harassing and reputational abuse. Like such a thing exists. Respondent's subsequent effort to weaponize and publicly mischaracterize the report. Wow, we're worried about it being mischaracterized. She must have wrote it herself as a made-up name. Was it Chase J. Jones who reported it even? We wonder. Demonstrates his ongoing use of intimidation, deflection. Yes, deflection is a crime, folks. And reputational abuse. More reputational abuse. Take a shot if you hear reputational abuse. Maybe I should have started with that. Second, the Human Resources Department, records custodian at respondent's employer in New York. The one we said we didn't ever contact, nor did we know who it was, but yet we do, is expected to confirm that the petitioners never contacted, visited, or communicated with HR personnel, and that no record, visitor log, or correspondence supports respondent's claim that she made an impromptu stop to discuss the existence of the DVRO. She could have waltzed right in there and presented herself as anybody. How would they know? Did they card her? I doubt it. More Laura fabrications. Although she probably actually did engage in the retaliatory behavior against his employer in New York, just under a different name. And I think that would be borne out in cross-examination. Collectively, this neutral records provide bullshit that is bullshit, and it's all irrelevant to 6345 anyhow. Joan O'Neill and Elisha Yosin Cook, former friend of petitioner and the attorney of record who handled petitioner's filing through the CROC. Oh, we have a friend who's an attorney. Really? Is that true? I wonder. Attorney J.C. will testify to the preparation and submission process, confirming that Ms. O'Neill's declaration was independently authored and transmitted through Croc. We have to declare independently and officially that the crock of shit being crocked by Laura Owens' crock of shit is crocking about Croc. Together, their testimony directly rebuts respondent's allegation of fraud, blah, 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 blah. And that any recantation arises from personal motives, not factual error, offered solely to address credibility issues in the present proceeding. Yuck. Miss Ariana Huffington. Yeah, right. Public figure known to petitioner's family through Daddy's professional career. Look at me, Daddy. I'm a real podcaster now. Miss Huffington will confirm that she has never met, spoken with, or interacted with respondent in any capacity, directly rebutting respondent's false public claims of association and thereby impeaching his credibility. Sure. Her testimony will demonstrate respondent's ongoing pattern of fabrication and self-aggrandizement that only Laura Owens could manufacture, further undermining the reliability of his representations to the court and to the public. We don't need that. We see Laura Owens' representations to the public, and I've picked my side. I'm sure most of you have as well, and it's not Laura Owens. That's just too bad. Ooh, I like this one. Okay, the rest of you are going to hate me for this, but I'm going to do it. So, too bad.
The owner and operator of Instagram accounts Justice for Clayton Official and victims of Laura Owens. Identity is unknown, and they are to be identified via subpoena by the platforms. They are expected to testify regarding the authorship, operation, and content sourcing for the Instagram account Justice for Clayton Official and victims of Laura Owens, which have engaged in coordinated online harassment, defamation, and indirect contact directed at petitioner in violation of the San Francisco DVRO. Petitioner intends to subpoena Meta Platforms, Inc. to identify the subscribers' registered email addresses, IP addresses, device logs associated with both accounts, as well as upload metadata for the posts compiled in Exhibits 22 and 23. The operator's testimony is necessary to authenticate those records, confirm content origination, and establish that respondent and or his counsel provided, approved, or directly coordinated the dissemination materials used in the posts. The operators are expected to testify regarding how private materials, including photos, videos, and screenshots known to have been in respondent's or his relative's exclusive possession, were obtained and uploaded. How respondent's unserved legal filings, including his CCP motion, appeared on victims of Laura Owens before petitioner was served, with captions stating, "Filings coming soon, approved by attorney," and his legal team has confirmed it, reflecting insider access and active communication with his respondent or his counsel. Any communications or coordination with respondent, his relatives, including Stephanie Ash, now Scanlon, or representatives concerning the publication of posts targeting petitioner. Metadata or message logs establishing that respondent or his legal team directly uploaded, authorized, or supplied content used to harass petitioner, including court pleadings, sealed materials, and defamatory statements, and the account's coordination with respondent's public appearances, statements, and filings, showing that the posts were timed to coincide with respondent's interviews and legal actions. This testimony will authenticate Exhibits 22 and 23 and establish that respondent has maintained ongoing communication with the operators of both accounts, constituting indirect contact harassment through third parties and disturbing a peace under that bullshit family code, which this doesn't apply to. Even if Respondent denies authorship, the operator's admissions combined with subpoena platform data will demonstrate that he knowingly supplied, approved, or facilitated the release of private litigation-sensitive materials. Such conduct is directly relevant to the permanent renewal of the protection order under that bullshit family code that this doesn't apply to, as it shows Respondent's continuing pattern of coercive control, reputational abuse, and disregard for court orders.
Okay, we had to get a little bit of pregnancy faker voice in there before the end of this particular filing. All right, hold please, and we'll switch to the exhibits. Alrighty, here's the exhibit list. Are you ready? How's your popcorn doing? How's your beverage of choice doing? Are you doing all right? Hanging in there on this Saturday? Thanks for spending it with me. I appreciate it. Be sure to hit that like and subscribe button. Hit that notification bell for all of my wild cubbyhole adventures. You don't want to miss out, folks. I get lots of kudos from lots of people saying, why aren't you bigger? I don't know. I don't control how my success works on this platform. We just try and do smart things and, nudge the SEO a little bit. I don't know how it works. It's beyond my IQ level, at least by a small margin. We're starting to figure it out, but that's the way it is. And I think as a special bonus, once we get to 1,000 subscribers and the possibility of being a monetized channel, I think I might do my first live. Yeah, I think I might have just enough. Might just have enough to hold it together. Then you can see how bad I really am without all of the editing. No, that's not true. Some of you see me on Lauren 90s Live. I'm just going to use that. That was my first public appearance, really. We'll see how it goes. We're a little ways off. We're a little over halfway. We've got a ways to go before we're at 1K, but sometimes that happens quickly, I've seen. Sometimes it happens very fast. You can get into tens of thousands overnight. I'm not holding my breath. We just plug along and we just enjoy doing this, except for the very small percentage of weirdos out there. Yeah, we all have weirdos. That means I'm doing something right. That's just how I know I'm doing something right. We get an occasional weird email or comment. That's the way it is on social media these days. If not, rogue lawyers saber rattling their law license in your direction. But that's for another day. All right. Hopefully you've had your little break. If you needed a bathroom break, if you needed to freshen up your beverage or your popcorn or treats, you've done so. And here we are with Laura Owens' exhibit list. Ugh, I wonder how long it is. I'm afraid. 1, the DVRO. And of course, we can't just list out what it is. We have to have an explanation for each one. This might take a minute. Okay, here we go. Number 1, the DVRO. It includes the original 2018 order, the 2020 renewal, and petitioner's 2018 declaration establishing a factual basis for protection through July 25. No, it wasn't a factual basis. It was uncontested, and he stipulated unwisely. That wasn't the best legal advice he was given. We are here to make it right this time. And there will be lots of contested facts, shall we say. Number 2, the related protective orders against Clayton Eckert and Greg Gillespie, none of which are relevant to any of this. Copies of active protection orders issued by other courts involving the same or overlapping factual circumstances. No, they aren't. Demonstrating the continuity of respondents' coordinated actions with individuals subject to those orders. I, Laura Owens, thusly declare that no one can talk to anyone about me unless it's to marry me. Won't you marry me? Marry me. Laura Owens wants some babies, please. Number 3, the Declaration of Laura Owens, 25, with exhibits. Filed in support of renewal, detailing respondents' continued... Why do we have to tell what it is? Reputational attacks, reputational abuse and reputational attacks, and reputational physical violence. That's what it should say, because it's equally bullshitty. Ongoing emotional distress. 4, Declaration of Attorney David S. Gingras, Esquire, which we've read. we're going to skip. I'm getting bored of this already because it's just all a wank fest. It's a Laura Owens wank fest. I don't want to watch it, quite frankly. I'm just a completionist and I want to get all the filings in. Number 5, a video posted by Clayton Echard. In that Instagram video, it shows Respondent and Greg Gillespie with Clayton Echard the day before the Owens v. Echard hearing. They can't do so. I, Laura Owens, have thusly decreed they can never talk to each other. They can never be seen together either. Psycho bitch. Number 6, video Respondent present for Arizona paternity case against Clayton Echard. Yes, we know he was there. Number 7, he was allowed to be there. He was subpoenaed as a witness. Number 7, article and video, exclusive interview. Second victim of Bachelor false accuser speaks out. The excellent interview by Megan Fox. If you have not seen it, folks, I'm going to say pause this right now. Go watch Megan's interview with Mike. It is fantastic, and it's very heartfelt, and it's just very authentic. It's marvelous. I've watched it a couple of times, trying to keep some things fresh in my head. It's heartbreaking to see what all of these men, of which there are at least a half a dozen in total, only a handful of them want to be public about it, but it's heartbreaking what they've all been put through. The bullshit by this psycho bitch. It is just terrible. Number 8, YouTube video. Breaking. Bachelor Clayton's accuser has texts exposed from previous boyfriend. 2024. And there's a YouTube link. I think we've seen that. I don't care. It's not relevant, really. It's a video with over 17,000 plus views, spreading fabricated messages attributed to petitioner, relying on leaked material, traceable Respondent and or Israel. Okay, wait a minute here. I'm pretty sure that might be one about the forensic analysis of the laptop. How can they both be real and both be fake at the same time? Can someone explain that? I don't think anyone can explain the irrational rationings of an irrational and psychotic woman named Laura Owens. Wow. Okay, the next one. Let's see. Website and archive, victimsoflauraowens.com. Shout out. We will include Volo in today's show notes. Actually, we might include a few things in today's show notes just for them because they're getting named here. Why not? We believe that the rising tide floats all boats here, except for the boats with holes in it, like Laura Owens, the Owens family, and Dingus the douche canoe.
The fucking douche canoe.
I was just looking for an excuse to push the button again. Sorry, moving right along. Number 10, Respondent's leaked video of petitioner's fall. How's it a leaked video if he took it? Who cares? Who cares if it came from someone else? Doesn't matter. And since it happened before the date, it doesn't matter. It's not admissible, as is most of this bullshit. Number 11, post from Respondent's sister, Stephanie Ash Marraccini, now Scanlon, under the Reddit username Justice for MM, allegedly. Where is the proof? Where's the proof? Where is the evidence? There is none. So it probably won't be admissible. The compilation of Reddit comments from Respondent's sister posted under the handle Justice for MM on r/Justice for Clayton. In multiple posts, Miss Scanlon publicly identifies Respondent as her brother. Mike is my younger brother and I could not be prouder of him. Anybody could say that. Anybody could claim that. There's no evidence that it's actually her. And asserts after his June 28, 24 interview with content creator Megan Fox that he is finally allowed to speak for himself, falsely suggesting that the San Francisco restraining order is no longer in effect. He is allowed to share his story. Tough shit. Her comments further include targeted attacks against petitioner and her family. Oh dear. Such as her parents bankrupted themselves because of her lies, which is probably true. Actually, Mom said that. Mom said that in the Daily Mail co.uk article that this whole incident, although falsely attributed to the men, but Mother said all of this caused the bankruptcy of the family, even though all of the bankruptcy says otherwise. The financial data of the Owens family suggests they have been poorly spending since the 1990s. Big Tiff dog, or Tiff as I call her because I get tired of typing all the words. My fingers get lazy. Tiff on Laura 90, the Court of Random Opinion, recently did a stream analyzing the finances and further analysis of the bankruptcy. A lot was uncovered there. Go visit Lauren at the Court of Random Opinion. That will be in the show notes as well. And go take a look at the financials. I'll admit it. All of the financial stuff, my eyes start to glaze over, and I get tapioca brain when we start talking about all of these funds and finances and how it all works. I just know that they're broke allegedly. They're not entirely broke. They have some money coming in, more money than I do, if I'm being honest. But 20 some odd $1,000 a month, that's a good chunk of change. But yet we're underwater a few $1,000,000. And that includes Laura, because Laura's finances are commingled most definitely, in my opinion. I think once Laura gets her financial roto-rooter from the courts, where she, as judgment debtor, has a full colonoscopy, I think we'll see some more things happen around the finances with the family and Laura. But that's just my hunch. Oh, this keeps going. Her comments further included targeted attacks, blah, blah, blah. Yes, the parents bankrupted themselves, probably at Laura's helping hand. Laura's whole family is toxic, which I think is quite true, and repeated demands to take down your fraudulent TEDx talk, Laura. I think in due course that TEDx talk will be coming down. I think it will. Chicken Soup for the Soul has already started. Well, they already yanked the digital version of that. A lot of stuff has disappeared. Isn't that funny? Oh, there's still more. Oh, God. These posts demonstrate direct coordination. No, it doesn't. With Respondent and an ongoing effort by his family to harass petitioner. No, it doesn't. Spread defamatory claims and misrepresent the status of the restraining order. No, it doesn't. Such conduct constitutes direct violations, blah, 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 blah. I'm going to skip ahead some more. Screenshot, Respondent leaking private photographs. An image confirming Respondent's release of private and explicit photographs of petitioner constituting a direct violation of the DVRO and continued abuse. What explicit photos? If such things actually existed, I think we would know about them. Someone posting themselves in panties and a bra, or, leggings and a bra, pretending to be pregnant by sticking out their gut, does not constitute explicit photographs. Yes, a number of states do have laws about revenge porn. I don't think there's anything here that will qualify. Folder, Respondent sharing private photos and videos on Discord. Honk my meat. Oh, good timing of that button. Screenshots and chat logs showing accounts linked to Respondent distributing private media of petitioner and her family on Discord, causing reputational and emotional harm. I don't think that's true. I don't think it is. How are we going to prove that? We don't say that. 14. Communications between Respondent's ex-partner Callie Subsinskas and McLean. Messages from Ms. Subsinskas acknowledging Respondent's volatile behavior and thanking petitioner for warning her. Oh, this is just listing out what we've already blathered on previously. Oh, well, we'll get through it. Declaration of Karen Ambro Bernatis. Napkin Lady. Moving along. Records. Pending subpoena. Well, that's not going to get very far in less than a couple days. We'll move along on that. Transcript and video from the interview by Megan Fox. Lovely. Moving on. More YouTube video stuff. Video from Dave Neal showing screenshots of petitioner's private message that could have only come from Respondent and associates. Whatever. Not relevant. Another screenshot. Someone likes to take lots of screenshots. I'll bet someone has hard drives and clouds full of screenshots. Comment on Instagram. Oh no, someone made a comment on Instagram. Under Clayton Eckert's verified post, Respondent publicly tagged at TED and at TEDx official, writing, "Enough is enough. Take down her completely fabricated TEDx talk about me. This is direct incitement of harassment and reputational attack, further breaches the DVRO's no contact and no harassment provisions." Bullshit. I need a bullshit button. Have I not written that down that I need a bullshit button? Oh, okay. Writing that down. Yeah, bullshit button. Okay. Oh, it is. It's bullshit. Like being able to tell these people that they're spreading defamation about him. He's allowed to do that. Tough shit, Laura. It's not a no contact violation by any stretch. More screenshots. Responder calling petitioner dangerous. Ooh, well, she is. She's very dangerous. You don't even have to look at her and she gets pregnant by you. It's just amazing. Instagram exchange between Respondent and Gillespie, against whom petitioner holds restraining orders, blah, blah, blah. Gillespie wrote, "Stop this woman. No one should cave to harassment. She is dangerous." And Respondent replied, "Dangerous is an understatement." They're allowed to have their opinions about you, Laura. Tough shit. It is not a violation. This public interaction constitutes a violation under all these codes that it doesn't apply under. Next, Joan O'Neill signed declaration supporting text messages, blah, blah, blah. I'm just going to blah, blah, blah through all this. Are you bored yet, folks? Have you run out of popcorn? Has your beverage finally run out? I should think by now you're probably getting to the end of those things if you've paused to take a little treat and a little break with us. Thanks for joining us on this weekend. I don't care about the messages by Miss O'Neill. And, some good stuff. The Instagram account. Compilation of posts from Justice for Clayton Official. Shout out! We may have to post some things. We may have to disseminate and share some of those things. And then we get into a long form thing about what this exhibit is. My God, it's a whole page. Laura being butthurt is what this is about. That's what all these filing lists are for. Laura's butthurt of not being able to control everybody. Boo-hoo. The account routinely posts private photos, videos, and screenshots. Obviously not, or they wouldn't have them. Known to have been in respondents or his relatives exclusive of possession. Prove it. Including materials shared privately but during the party's relationship. I'll bet a lot of that stuff was gleaned off social media, would be my hunch. That doesn't make it private. False, humiliating, and inflammatory statements about petitioner, including that she is a serial liar, mentally unstable, and dangerous. You can take all those to the bank. They're absolutely true, in my opinion, and in the opinion of the family court. And that was found to be true as a matter of law by Judge Julie Mata during Owens v. Eckerd, for which she was referred for criminal prosecution. I'm surprised it doesn't say defamatory statements, because that's usually her favorite word. Maybe it's a typo, because we have court orders that say otherwise. Hashtags. Oh dear, someone doesn't like being listed in hashtags. Okay, note to self, I need to put lots of hashtags in the show notes for this one. Posts published in close coordination with respondents' own appearances, comments, and family act. Who cares? Doesn't apply. The consistency in tone, timing, and use of private materials, because Laura's going to be her own expert witness about who wrote these things. Or persons acting under his direction. Prove it. Have actively provided this account with content, commentary, or access to personal media and information. These actions amount to knowing and willful violations of the prohibitions. Yeah, sure they do. Skipping. 23. Instagram account. Victims of Laura Owens. Shout out. Compilation of selected posts from Volo, which has repeatedly published defamatory, no it hasn't, and harassing content. Oh dear, concerning petitioner in these proceedings. The account presents itself as representing respondent's side of the story, repeatedly referring to him as the victim, which he is, and echoing phrasing used by respondent and his attorney in filings and media interviews. These posts demonstrate direct or attorney-facilitated involvement by respondent through their content, timing, and exclusive access to non-public materials. Examples include posts stating, filings coming soon. Does that work? I tend to miss the ones that say coming soon. I just see the ones where they're actually there. Our attorney approved this, and his legal team has reviewed and confirmed it. Phrasing that reveals a direct access to respondent's counsel and advanced knowledge of litigation events. Who cares? All you usually have to do is look at the docket. Once things are e-filed, I'm told, they appear rather quickly, even if you haven't received them yet. Uploads of court pleadings, including respondent's motion, which appeared on the account within hours. Oh no! Oh dear! Oh, someone just doesn't know how things work. The presence of file stamp headers and formatting identical to respondents. Digital copies establishes that these were provided by respondent. No, it doesn't. Oh, God. This is giving me a headache. Okay, we might have to wrap this up a little faster than I want to. Yeah. Moving along. I don't need a migraine for this stuff. Posts quoting specific lines and claims, responding, blah, blah, blah. Parents went bankrupt because of her lies. Well, that's what her mother said in Daily Mail UK. I've already said that. Captions including, Mike finally gets to speak for himself, which he does. The court will see through her fraud soon enough, which they will. And San Francisco should not let her renew her bogus DVRO, which they shouldn't. Direct references to attorney approval and legal team coordination, that proves nothing. It's irrelevant. Moving along, the timing and insider nature of these posts, especially the publication of unserved documents and filings, prove that no, it doesn't. That they're leaking and authoring. No, it doesn't. This exhibit establishes that respondent has continued to disturb petitioner's peace and reputation by using third parties and social media intermediaries to disseminate privileged court material, false statements, and humiliating commentary. Tough shit. None of that's true anyhow. You don't have to seek it out, Laura. You can turn off the device. You can. And if you're hearing this, you should turn it off right now, but you won't. It feeds your infatuation. You have a sick, sick need to be fed by this. It's gross. It's disgusting. Ew. Skipping ahead, 24 voicemails from Peggy Marraccini. I have audio recordings, blah, blah, blah. Messages that show petitioners not returning calls after I intimidated him, etc., etc., etc. Blah, blah, blah. I'm a stage 5 stalker right now, but I just want to hear your voice and know you're okay. Blah, 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 blah. These voicemails confirm that petitioner was not seeking or maintaining contact, directly contradicting respondent's current narrative that she was obsessed or fixated or unable to move on. Instead, they show that it was respondent's family pursuing petitioner after the relationship ended. Bullshit. And what's next? Is this the end? Oh, thank God. While recorded prior to 2020, they remain relevant. No, they don't. And they're not going to be let in. So forget it. Tough shit. Okay, that's enough of reading for today. Oh my goodness, we've gone on for an hour or so. This just goes to show. This is Laura trying to litigate being butthurt. The vast majority of things she claims are relevant, because she wants them to be, have nothing to do with the DVRO. I'm fairly confident that the majority of them will not be admitted, even if she knows how to admit things into evidence, which I'm not so sure about. It's not going to go well for her, I don't think. Now, I have a bet. I have a bet that she will show up. I think she will show up mostly because she's required to, not because she wants to. And I also suspect. I have a hunch that I think Dingus the douche canoe,
The fucking douche canoe.
will also be in attendance, physically. Not just to be a witness, but perhaps, I think, as we have seen given the Owens v. Eckerd, to try and coach Laura on how to be an attorney for her own case. He might sit there in the front row. It could be very, very interesting watching indeed. We'll rely greatly on our eyes and ears on the ground in the courtroom, Megan Fox and others. I think Lauren might be there. I'm not sure who else might be going. I think Steve with 2 E's and a V, might be in attendance. There will probably be some other people. I don't know who they are necessarily, but whoever will be reporting on this will certainly share their stuff, and we'll be on top of it as soon as it gets released. Keep your eyes and ears open and to the ground for all the latest craziness coming from psychotic, fraudulent, con artist bitch Laura Owens. And until then, we'll see you next time.